Welcome to the Estate Planning Made Simple podcast by LSPN, one of the nation's largest and best estate planning networks. The information provided on this podcast does not constitute legal advice. All information, content, and materials available on this podcast are for general information purposes only.
All right. Thanks for joining us today. This is the first of many podcasts that we're going to be doing, and we are excited to invite those that are attending live with us. You know, what we're going to talk about today, I think, is a very important topic because over the last couple of years, we've seen everything from pandemics to hurricanes to floods to, I remember seeing a report just about a year and a half ago of somebody's house that blew up simply because, you know, they had a natural gas leak under the house that they didn't know about. And all of a sudden, the house and half the neighborhood just blew up out of nowhere, right? We've seen apartment buildings collapse and, you know, all kinds of crazy things that who would have imagined that we'd even see these things in today's world. But the thing is that when these emergency crisis sort of situation happen, the most important thing that you can have is the right documents to empower somebody that you trust to step in and to be able to help manage and take care of the situation. Without those documents, then everything ends up in the court system, and it can be a long process, it can be an expensive process, and it can be a very stressful process to be empowered or to empower somebody to be able to handle those needs. So what we're going to talk about is what we call estate planning. But sometimes that term turns people off, right? Sometimes people say, well, estate, I don't have an estate. I don't own horses. I don't have a 7-car garage. I don't have a mansion, you know, so I don't really have an estate. And we kind of filter ourselves out of thinking that we actually need to do estate planning. The reality is that all of us have an estate, and it's not a matter of what you own. It's a matter of who you're leaving behind and whether we're putting things in place to protect them and to take care of things in the case of those emergencies. So I just want to share a couple stories with everybody today about how that can relate to even the most basic of scenarios where sometimes we would imagine that there's no need for an estate plan. I remember, growing up, I'm from Southern California, and my sister went to school in San Diego. So as she's studying, she's not married at the time, doesn't have any kids, doesn't own any real estate, no significant assets of any kind. And most people would have said at that point in her life that she didn't need an estate plan. But she found herself unconscious in the hospital, and the hospital called my parents and they asked them if they had a healthcare directive or a medical power of attorney or a HIPAA authorization or anything like that. And of course, like 80% of Americans, they didn't have anything in place. And so that's what they answered. And the hospital said, well, we can't tell you anything, but your daughter's here. That's a stressful phone call to get as a parent, right? And unfortunately, the reason for it was because my sister at the time was 19 years old. So she's an adult. She is considered under the eyes of the law to be fully independent. And nobody can receive any of her private medical information without proper authorization. And even sometimes between spouses, we imagine that these things are automatic, right? It's not automatic. Your parents can't automatically make decisions for you. Your spouse can't automatically make decisions for you. And so in the case that there's liability for the medical facility, they're probably not going to share that information unless they have something in writing. And in the case of my sister, my parents had to travel for 2.5 hours to get to the hospital. And luckily, by the time they got there, she was conscious, she could get permission, and everything turned out okay. It doesn't always turn out that way. And so even a basic document like a medical power of attorney, a HIPAA authorization, or a living will can make all the difference in the world in the moments of those sort of crisis emergencies. So we recommend for practically everybody medical power of attorney or its equivalent and financial powers of attorney. And again, these things are not automatic because if my wife goes to the bank and she says, Glen has an account here and he's in the hospital or he's, in a coma or whatever the situation is, or like one of my friends, a couple of years back was accused of a crime and he had to go to jail for a period of time. He's a business owner. He had several hundred thousands of dollars that were able to be collected, that were in his business bank account, that was paid for by clients that the family could use to be able to pay for expenses. But because he was in jail, he didn't have access to that money, and his wife was not on his business. So she wasn't a co-owner of the business, and she didn't have access to the business bank account. And so all of a sudden the family doesn't have any money and there's no cash flow. We had to help him to get a financial power of attorney in place in order for her to have access to those things. And again, if you show up at the bank and you say, my spouse has an account here, can I access it? Unless you're authorized on the account, they're not going to give you access. And so it's very important to have these documents. We had another client who her husband had a stroke, and every time that the hospital called to follow up and to talk about medication or to talk about billing or to talk about anything, they asked her to put her husband on the line so that he could give permission for them to talk to her. And that makes sense, and it's common, right? But she stepped back at one point and she said, he had a stroke. That affects mental capacity. What if he wasn't able to get permission? What if he's not able to intervene and give them permission and authorize me to talk to them? Then would they not give me the information? And the answer is, legally, they don't have to. And so, again, these situations can be very scary if you don't have the right documents in place, and that's why we recommend them for practically every situation. So I want to share one last story, and then we'll talk about just a little bit of the basics here. But the last story was shared to us by somebody down in Southern California who was also in college, and one of their roommates had mentioned to other girls in the dorm in their sorority that she had gone through a very significant breakup, and we all know the story. She's sad, she's trying to get over it, she's depressed, and she mentions that she's thinking about ending her life. So the other sorority girls are scared. They call campus police, they report it. She's put on a 48-hour suicide watch. So in the meantime, the parents are trying to get a hold of her. They're calling the university, and the university is not giving them any information. They're calling campus security. Campus security is not giving them any information. They're calling the hospital, and the hospital's not giving them any information. The only people that they're able to get any information from are the other sorority girls who don't have the full story, and their version of the story sounds pretty scary, right? And so these situations become very scary when you are not able to get a hold of somebody who can provide you with information, who can answer questions, who can give you access. And without the right documents, unfortunately, there's no way to be able to do that. And so, these are things that we recommend. Again, once you turn 18, it's important to have even basic documents in place. And those documents could be as simple as a financial power of attorney, a medical directive, medical power of attorney. And once you have children or when you're married, then it may be time to consider a last will and testament. We'll spend more time on wills and trusts and those sort of instruments in the future. But for today, the most important thing to consider, especially for young people, young families, is when you do your estate plan, it's not just about the stuff you have. It's about having access to information. It's about being able to make decisions. It's about deciding who's going to raise your children, naming the guardian for your kids. If you don't name the guardian for your children, then the state has a process where any interested party can nominate themselves to be the guardian for your kids. And they may not be the people that you would prefer to be in that role. But unless you put that in writing, you won't have a say and you won't be able to argue your point. And so it's important to address these things proactively before the emergencies happen. And I can't tell you story after story after story that we hear after the fact that unfortunately people didn't have a proper plan, and it becomes a nightmare to try to resolve when there wasn't documents in place. So if there's anything that we can share with you today of action items that are important, that are valuable, would be that. Get some basic documents, make sure that they're in place properly, update it every few years to make sure that they're addressing your current needs. And To the extent that you have children, again, it's important to have a will. To the extent that you have real estate, it's important to have a trust. Otherwise, you're going to end up in the court system. And we'll talk more about these sort of plans and strategies in the future. Again, thanks for joining us. And at this point, we usually open it up for some question and answer. So the question is, if you do documents in one state and then you move, or you're traveling to another state, maybe you're studying in another state, will those documents still be valid, or do you have to redo them? The answer is, every state gives full faith and credit to the documents, contracts, and other, legal documents that are created in the United States in general. So if you do a plan in California, for example, and then you're studying in Nebraska, that plan will still be valid. It may have a different effect based on local law, but the documents themselves will be honored, will be valid, will be able to be used. And so, again, just having a plan in any state is better than having no plan at all.
Thank you, Glenn. I actually did receive one other question. If you have a plan in place for your children in that kind of scenario you were talking about, and then you have another child afterward, does the plan need to be updated or changed?
Yeah, so we will, again, be going into more detail on wills and trusts in future podcasts. But, that's a great question. If you set up your plan, any life changes, any major life changes are perfect opportunities for you to review your plan and make sure that it's still up to date and it's addressing things properly. That being said, most plans that you would establish are going to include afterborn children or possibly even adopted children after you've established your plan. And so if you've set up your plan and maybe at the time you had 2 children and now you have 5, those other 3 are still included in the plan if it was structured to allow for that. And most of them are. And the other thing I'll share on that point is that when you set up a plan and you establish it, again, for the possibility of future changes, again, it's important to review the plan because sometimes we forget who we put in charge of what. So we had a client that we met with not too long ago. We were reviewing their plan. They had done a trust and they had, wills and powers of attorney and everything. And they had done it about 10 years previously when their kids were very young and they only had, 1 or 2 children, and now they had 4. And so they were worried about updating it. We looked at who they had named as the guardian for their children. We also looked at who they had named on their power of attorney as the agents and the person that's going to be in charge of the trust as the trustee. And they had listed their neighbors, which was probably not a bad choice at the time. But I asked them, when's the last time they talked to their neighbors? They hadn't talked to their neighbors in 3 years. They didn't even know where they lived anymore. They hadn't seen them in probably close to 7 years. And these are the people that they had left everything to. So it's important not just to have a plan, but to make sure that you're updating it.
This has been Estate Planning Made Simple, a podcast by LSPN. Join us next week on Clubhouse and on all major podcasting platforms.